Hello, everyone. You're going to want to grab a pencil and paper for this month's episode because I review a federal change happening around independent contractor classification rules. This is something we go back and forth on. And while it's a really smart business strategy and many employers utilize it, it's only if the classification matches reality. Otherwise, misclassifying somebody as an independent contractor can be a very costly mistake. So with that, let's jump in. Welcome to the March edition of HR Hot Topics. I'm your host, Jodi Schafer, and my aim is to make this the most informative 10 minutes of your month. I shake my head like that because it's never quite 10, right? So this month, I'm hitting on a topic that if you've been a longtime listener of HR Hot Topics, you've heard me talk about before, the last time of which was in 2024. And that is the distinction between an independent contractor and a W-2 employee. Why am I talking about this again? One, it continues to be a really difficult part of employment law to make sure you get that classification nailed down correctly because there are so many factors to consider and there are multiple tests and they don't all match. But the other reason I'm talking to you about it is because at the federal level, there's been a notice of a proposed rule change around this independent contractor test. So on February 26th, the Trump administration, the Department of Labor, issued a notice of a proposed rule change, and this is what happens when Congress is dysfunctional and we don't have laws coming through congressional ways. We also have this administrative rule change that we can do, and both sides of the aisle do it. But essentially, we look at a law that's already on the books and we say, we interpret that differently. And here's our interpretation. And so when that happens, the federal government has to publish their proposed rule change. So the language that they are going to use going forward, they have to post that in the Federal Register for all of us to see. And then there's a 60-day comment period where we can weigh in. We being employers, citizens alike can weigh in. And then they will come out with their final rule and a future effective date. So around this independent contractor rule, it's been a bit of a seesaw. When Trump was in office the first time around back in 2021, the Department of Labor under his administration looked to really streamline that independent contractor test to make it more simple to apply, to really focus on the economic reality and degree of control that the employer and the contractor both have, and in essence, to make it easier for folks to fall into that independent contractor category. So it was back in 2021. So we all adjusted. And then in 2024, the Biden administration took a look at it and, of course, had a very different take on that. And they did this whole rulemaking process again, where they published a new version of how they will be considering independent contractors. It was a much more lengthy test. It looked at several different factors, but in essence, really narrowed the gap on who could be considered an independent contractor. So that was back in 2024, and that's the last time I spoke to you all about this. Well, when Trump took office the second time around, one of the first things the Department of Labor did under his administration was to say, yeah, we know that rule's on the books, but we don't agree with it, and we're not going to apply it to any of the investigations that we do. So we've sort of been in limbo a little bit because, the rule still says what the rule says, right? So now fast forward to last week when the Trump administration now is proposing that revised language to basically codify in the law what it is they said they were going to apply when they did the investigation. So they're going to kind of go back to this 2021 idea, which is to streamline the test for an independent contractor. And I'll read to you a couple of the key points of this proposed rule that is now in the Federal Register. You all can read it, and I'll put a link to it in the email message if you want to do so. But essentially, the Trump administration wants to go back to this economic reality test They want to look at two core factors. The first is the nature and degree of the worker's control over their work. So the more control the worker has, the more likely they could be considered independent. And then the second factor is the worker's opportunity for profit and loss based on initiative and or investment. Again, the more opportunity they have for profit and loss, the more likely they could be classified as independent. However, sometimes the answers to those two questions point in different directions. And so in that instance, this proposed rule identifies 3 additional factors that an employer could use to help with their analysis. The first is the amount of skill required for the work. The more skill, the more likely you could be considered independent. The degree of permanence between the relationship of the worker and their potential employer. The more permanent and long-term the relationship, the more it starts to feel like an employee relationship, a W-2 relationship. The more short-term that the nature of that arrangement, then potentially feels more like a contractor. And then the third, whether the work is an integrated part of the production of what that employer puts out into the marketplace. So, for example, I have a lot of clients who are dentists, right? Their primary service that they're offering are dental services. If they bring in an individual, even though they are very highly skilled, okay, and potentially for a short time, but they're performing dental services, which is what the dental office does, that may start to feel more like an employee. So the tricky part with all of this is that there's not a bright line test. I've just listed 5 factors, 2 of which are considered core in this new proposed rule. It is a streamlined version of what was in place under the Biden administration, but still it says you have to look at the totality of the relationship and basically make your best guess, okay? And document why you've classified people the way you have, specifically your independent folks. If you have a contract in place that spells that out, even better, but simply having a contract doesn't make somebody an independent contractor, but it's a good practice to have one and spell it out. Because here's the thing, independent contractors are their own business entity. They pay their own taxes, right? They're not held under your work comp insurance. They're not covered by all the same employment rules and laws that your W-2 employees are. Once the relationship ends or the project ends or the contract ends, they're not eligible for unemployment benefits. And so, depending on which unit of government is looking at this, they all have vested interests. And many units of government feel much more comfortable when the employer is managing all of those components. They trust the employer perhaps more than an individual person sort of operating as a single shingle. So they like it better when the employer classifies everybody as employees, W-2, because then the employer is absolutely making sure all those payroll taxes get paid, and there's work comp insurance, and they're paying the unemployment insurance, right? And all the employment laws relate to those W-2 employees, and so they have all those protections. So there's a lot of vested interests and incentives, I think, in place to classify as many folks as possible in that W-2 category. But it's incredibly expensive for an employer to do so, and not every relationship requires that you put somebody on staff for the foreseeable future in order to get the work done. So as an employer, we really like the flexibility of being able to have contractors and W-2s. We just have to make sure that we're making that distinction appropriately. To compound this a little bit, as I said in the very beginning, there are different types of tests to determine if someone is independent versus W-2. So I just talked about a change happening at the federal level that's really going to kind of shift a Biden-era interpretation of this and focus it much more on a streamlined economic reality test. In Michigan, which is where this is being filmed, the courts have long sort of used this economic reality test when they are taking a look at a classification question. But our unemployment system here in the state of Michigan and our workers' comp system here in our state look at the IRS 20-factor test, which essentially is looking at control, but it's looking at control in terms of behavioral control, financial control, and the nature of the relationship. And under each one of those subheadings, there are all these various factors. So, I've got that here, and I'll link to this too so you can take a look at it. But essentially, it just kind of muddies the waters and creates more confusion around this issue. So I want to leave you all with a couple of pieces of advice. One, when you're trying to decide whether somebody should be classified as W-2 or independent, you need to look at the entire nature of the relationship. As I said, just simply having a contract in place isn't enough, or being able to answer yes to a couple of these factors but no to everything else isn't enough. You need to really look at the whole nature of the relationship. The more control the individual has over their work, their schedule, the ability for profit and loss, the amount of skill needed to do the job, the shorter that relationship, especially if it's kind of project-based here and there, and especially if the work that person does is not a core service that you as the employer are offering, the more likely you'll be able to classify them as independent. And in those cases, I would make sure that you absolutely have a contract that an attorney drafted for you, not that you drafted for yourself or went out to AI and had them pull down. Because the documentation is going to be important, right? It's not the title, it's the actual working relationship day to day that is going to factor into this. This is important. This is a really costly mistake to make. So if you ever get called out on this, a misclassification of somebody as 1099, and they should have been a W-2, you're going to have a lot of financial exposure. There are fines. There are wage and hour rules, especially if this person is deemed to have worked more than 40 hours in a given week. You've got overtime obligations. You've got some back pay issue potentially. You've got the taxes that are now owed that weren't paid. You might have an unemployment, component, a work comp component. Like, it gets very expensive very quickly. So this isn't the kind of thing that you just want to leave up to your gut. You want to have a professional take a look at anyone that you currently have classified as 1099 and just run it through, whether it's this new refined economic reality test that we should see final language on in the coming months, or whether it's this 20-factor IRS test that the Unemployment Insurance Agency here in Michigan and Work Comp use. There are some things to guide you in this, but professional assistance is always recommended because you just don't want to get this one wrong. So I'll put some resources in the bottom of the email, as I always do, to help you in this area. Of course, if you have any questions, you can reach me directly at Jodi Schafer at workwithhrm.com. And before I go, I want to remind you of two things that are coming up, one in April, one in May. And that is our leadership training. We do a lot of training here at HRM. It's one of the things that we are most known for. We started offering in-person training for leadership a few years back. It's become a staple in our annual calendar. We separate it into two sessions because there's a lot to learn. So session one, which is fundamentals, is taking place on April 22nd in the Okemos area here in Michigan from 9 to 4. And then the second session, which focuses on the hard part of leading others, right? Diagnosing and treating employee issues. That's on May 20th, also here in the Okemos area, 9 to 4. So I'm going to put links to each of those in this email message as well. Seats are filling up, and we do have limited capacity on that. So I would love for all of you to take a look if that's something that you think would be beneficial to your team. And for those of you that live outside of the state or travel's just not feasible for you to the Lansing area in April or May, we do have an online option as well on our learning management system platform, HR Hazmat, with some revised pricing and group discounts. And so that's always an option as well. We want to make sure that we can support you in any way that makes sense. So with that, I'll leave you. We'll pick this back up in April.